Hi there, I'm Clifford Bates, and this is going to be an announcement of what we're going to be doing soon, or after the politics. Yeah, and I want to know if people want to do it. That's what. If you want to do it, interested in doing it, then like it, like it, like it. If you get enough likes, then I will probably try doing it. It is going to be. We're going to be looking at the spirit of the laws. We're going to be looking at Montesquieu's Spirit of the Laws, a classic text, which I think in many ways is like on par with Aristotle's Politics. It is a fundamental text. It's played an essential role in the American political founding at the founding of the Constitution. Both sides of the pro and against the Constitution looked at Montesquieu's Spirit of the Laws as though it's was important to this, and a book that we're looking at. We're going to be using the one of the a new modern translation. It was actually from the 80s, late 80s, early 90s, by Ann Kohler, who died finishing it. Ann Kohler was a student of, I think, Joe Cropsey at Chicago, and her specialization. Her very book on Rousseau and nationalism was a very outstanding book. And she wrote a book about, before she died, on the forms of government in Montesquieu. It was a very good book, and that this translation was continued by Harold Stone and Basha Carolyn Miller, who finished off where she did in the editing. And this is the first really modern translation of the politics for hundreds of years. I mean, the Spirit of the Laws for hundreds of the years. Um, the Spirit of the Law is a very, and if it may say 1998, 1989. I remember this when it came out. This is the 20th printing in 2015. That's the famous line from the problem scene meta Goomba the world, from Ovid Metamorphosis, right? That's how he introduces the thing. This translation is a very good one. It has a very long account of introduction, and then a discussion, principal events of Montesquieu's life. So that a preface by the translators, the abbreviations list. Again, this is the Cambridge edition. There's many. I have the. You see, I proved my first volume. Here's the first edition volume I had from the 80s, 89. The old cover. You can see it's older. And I have one written up even now. This is a couple years ago, and there's even a more modern one which has different color, lighter color, which I don't have. It's in the library. It's my office. I taught this book many times. It's one of my, with the Aristotle's Politics, is one of my favorite books. Um, it's in French. I have my French copy is. I have this big monster. All of that. I don't have a small. Maybe I should have my own small. I haven't spent as much time in the French with this as I've spent with Greek in the Aristotle. So let's say, and that's probably because the, the the translations in Aristotle are more nuanced, and ancient Greek and modern, and many translations are kind of, there's a gap where French to us is closer. So even the older translations were mostly accessible. The only reason why we do modern translation is to catch the subtleties in the French that were sometimes overlooked in the early translations, or the translators just kind of didn't pay attention to, which this translation does, and some of the recent translations of Rousseau similar does this. So let's look at the reality for a second, and this I'm going to start. I'll just look at this and say, okay, this is fun. Why we're going to do it? I think it is. Montesquieu is divided in parts. It has 6 parts in that sense. We see right there, right? There are continually 31 books, 6 parts, with a little teeny author's preface, and a preface. Um, the biggest, weirdest thing is, well, I mean, they're divided in certain themes, like the introduction is introduction, and that's one of the things about the Spirit of Laws, is that it doesn't seem to have a clear pattern. Okay, it's one of those books, and this is why probably it's too big. It's a monster. It's a very outwilled book, and a lot of the European thinking didn't like it, because it wasn't as clear. If you look at compared it to something like Rousseau's Social Contract, which is very small, this is huge, and it's no clear pattern. It's some people argue this it's a hodgepodge of different things. There's no order here. Some people argue there is an order. I argue there is an order. There is a order that you have to discover. And there's a lot of things that are said that are not said, that I think this is where I kind of disagree with someone like a person who I really respect, David Starkey, who thinks this book is horrible. Not horrible, but he thinks it's wrong because he reads this section on England, the famous chapter on England, too literally in that sense, and also he doesn't really pay attention to the actual text in this one sense because he attributes to he attributes the account of the division of powers uh, um, as being an account of the English Constitution, which the chapter on England, I think this is the problem because sometimes he will announce a title. Montesquieu does this a lot of times in his work. He will announce a title of what's he doing, but what then he will do is give, instead of going directly into the theme, he will then go into and go into exactly to that point. He addresses a larger point first, and then the actual discussion is an aspect of that larger point. And I think what the famous account in England in chapter book, in book 11, let's say book 11, this is like there on the forms of political liberty in relation to its constitution, right? Let's go to it. I have to be careful because it's not going as fast as I want it to go. Uh, I don't want to get this really screwed up. I know I have to go through here. I just want to make a point. I think it's interesting for you as a starting point. Is this what is this? Chapter 2. This is book 13. Okay, so I'm close. Okay, it's book 11. Correctly. Yeah. Okay, there it is. Book 11, the Constitution of England, chapter 6. And he see how he goes, and then he goes on the Constitution of England, right? Then he goes, in each state there's three sorts of power. This is the famous division of powers claim. Starkey and many people argues, well, this is what the whole point about the English Constitution is. No, I think this is a misreading, fundamental misreading of Montesquieu here, that and fails to understand. This is Montesquieu's approach style is sometimes to kind of, I'm going to talk about this point, but then it's kind of like I want to talk about division of powers. I'm enabled to discuss what is what really shapes the Constitution of England. I need to address the question of division of powers in a way, not because England represents division of powers, but the thing that makes English, this again, this is about political liberty in the Constitution, right? The whole chapter is focusing on. Let's look at the chapter. Look at on the laws that form political liberty in relations to its constitution. So, what about the English Constitution that relates to liberty, political liberty, right? That's the thing. And now he brings up division of powers because this is not only true there, this is true everywhere. And the account here is a general account, not one specific to England. He gives, he talks about Italian principates, the different republics. He spends a lot of time on Venice, and then he goes only like about things about tribunals, and then he goes, uh, 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 um, and he talks about the power of judges, right? And he goes like this, and he says that about the question of legislative power, judicial power, and executive power, like why they need to be divided. And then he comes up here and he goes about different Germany, and then goes about Holland, right? And then the question of this and the great vices of ancient republics were not uniform. And again, this is all this is about a general account of division of powers. We only get something to England is very at the end, and it's a weird account. Now, um, it's a very long chapter. This is what keeps on going. It's all the way down here, the Holland, Venice, the other examples, right? And he goes, I do not wish to claim to disparage the other governments or to say this extreme political liberty should humble those. Okay, no. It is not for me to examine whether at present the English enjoy this liberty or not. It is suffice for me to say that it established by its laws, and I seek it no further, right? I do not wish to claim to disparage other governments or to say the extreme political liberty should humble those who have only a moderate one. Uh, uh, um, uh, um, However, I should say, I believe that the excess of reason is not always desirable and that men always accommodate themselves better to the middles and to the extremes. And then he gives this example of this line from Harrington, right? Oceana, the famous Harrington, the British writer who some people, the British Cambridge School people say he's the Machiavellian transmission, but no, he's a weird civic humanist. I mean, he is he's a Republican, but he's a Republican. He has kind of a weird thing, Oceana. It's an ideal utopia, right? But this is a criticism of Oceana, right? He says, has Harrington Oceana has examined the furthest point of liberty with which a constitution of a state can be carried, but to him, but of him it could be said that he sought this liberty only after misunderstanding it, and he built on Clarendon, which means England, in that sense, with the coast of Byzantium before his eyes. In other words, he was looking at Byzantium, not with this Calderon. So, I mean, but what is so interesting about this is what makes, I think, here is his idea of judicial power, and not judicial power, but of juries. What in the character of juries in that sense, and I think the character of the British juror. Um, uh, And I think that is what he says, legislative bodies and things like this. And I think what he does is he looks at the way that the English have done things, the legislative bodies and things, in light of his point, and makes the point about the British Constitution. That there's not really an executive separation between executive. He's not arguing that there's a clear separation of executive and legislature. He doesn't think that. I think the English Constitution kind of blurs that. But what is the point is that um, the power of judging, right? And what is the power of judging in here? He says that the role of judging and things like this, um, and is where is that line? He says, although in general the power of judging should not be joined by any part of the legislature, this is subject to three exceptions found in particular interests of the one who is to be judged, right? Important men are always exposed to envy, and if they were judged by the people, they would be endangered and would not enjoy the privilege of the last citizen of a free state, of being judged by his peers. Therefore, nobles must not only be called before ordinary tribunal, must not be called before ordinary tribunals of the nation, but part of the legislative body composed of nobles. And I think that he's talking about the House of Lords, right? And therefore this is how he does address the English in that sense. The English lords are due before the court, not a mere popular court, right? The Star Chamber, also these things like that. It could happen that the law, which is simultaneously convoyant and blind, might be too rigorous in certain cases. But the judges of the nations are said to have had only the mouth that pronounces the words of the law, inanimate beings who can moderate neither its force nor its rigor. Therefore, the part of the legislative body, which we have just said is a necessary tribunal on other occasion, is also one of on this occasion. For it is as a supreme authority to moderate the law in favor of the law by pronouncing less rigorous than the law. So therefore, there is there is something in the judge that exercises a legislative element. It can moderate a law. Okay, it says it can interpret the law in that sense. It can, in other words, there is something legislative in when you act the law and try to understand that. Well, the law. If I just merely obey the law, then things could be too rigorous, too vicious. If the law says this and this, and if I just follow the specific written aspect of the law, this can be end up being unjust or problematic. Montesquieu here is kind of saying, well, no, no, no. Let's look at this in this sense. And he goes, so therefore, therefore, if you give the judge the ability to interpret, he's acting as the legislature in that sense. He is kind of looking at the law and moderating the law in a sense. Okay, this is what he says. This is the blending of office. This is where there is a kind of division of powers. There's separation, but there's also a merger at a certain point, right? And it's not a clear blanket separation. That's why it's interesting. I think Montesquieu's account here is a very interesting, nuanced one. But it also happens that citizens in matters of public business might violate the rights of people and commit crimes that established magistrates could not or would not want to punish. But in general, the legislative power cannot judge, even less so in this particular case, where the representatives of the interest party, the people. Therefore, it can only be the accuser. Okay, this is why you have to have tribunals of accusers, not as of the interest party, the people. In other words, therefore accuser. But before whom will it make the accusation? Will it bow before the tributes of law, which are lower than it, or and are moreover composed of those who are being of the people would be swept along the authority of such a great accuser? No. In order to preserve the dignity of the people and security of the individual, that part of the legislature drawn from the people must make its accusation before the part of the legislature drawn from the nobles. Okay, so therefore, this idea that the legislative accuser, like this, there has to be a like of this, and that therefore there's a check, right? There's this built-in check in the logic he's trying to say, and that is in the English system, right? In that sense that, and he continues. He says, um, uh, which has neither the same interest nor the same passions. The last is the advantage of this government, moreover, of its ancient republic, of the ancient this government here, where was an abuse that the people were judged and accuser at the same time. Okay, the ancient system was that the people were both the judge and the accuser. That one of the accusers were there. So therefore, it was the assembly acting, the people as the assembly, and the elements of the people are acting as the accuser. So there's not really a separation there, he says. The executive power, as we have said, should take part in legislation by its faculty of vetoing. Otherwise, it would be stripped of its prerogatives, right? But if the legislative power takes part in execution, that executive power will equally be lost, right? The idea now, if the monarch took part in legislation by the faculty of enacting, there would be no longer liberty. But in spite of this, he must take part in legislation in order to defend himself. He must take part in it, but the faculty of veto, right? That's the whole point. The case in the change of government in Rome was that of the Senate, which had one part of the executive power and the magistrate who had the other. So, in this account of the division of power, he's kind of showing not only the English. He's pointing about the English Constitution about liberty. His point is that the English have the best situation of preserving liberty. Okay, that's the whole point of this. In other words, the English Constitution is held up as, and actually, the English Constitution is kind of, in a way, presented as a republic, not as a monarchy. And I think this is an interesting thing Montesquieu does. And I think I think this is where something like even Starkey would have to agree that the English Constitution is And I think Starkey is Montesquieu is doing this purposely because his three governments are republics, which are divided between democratic and aristocratic, um, monarchies, and despotisms. And his despotisms there, and he gives France as an example of a monarchy. Um, I think he does this politically. I think what happens is England is the monarchy. Okay, a better example of monarchy than that. Or if but he calls it a aristocratic republic, because I think this is his way of avoiding calling the France that he lives a despotism, the France of the. I mean, that's what I suspect. I suspect this is kind of an esoteric. This is it's a rhetorical trick that Montesquieu engages in to avoid calling a spade a spade. And I think this is what's so interesting about this. He goes, the forms of three powers should be rest in action, but in their constraint to move by necessary motion of things. They are forced to move in concert. So therefore, I'm going to skip here. I'm not going to do this whole chapter today. I will do it again when I read the thing. Um, what's so interesting about here is about the role of judging. Right. This is why I think this is about the question of how judicial authorities and how the jury system is not a permanent body. That might be even earlier, right? Let's go all the way back up here, and he goes. Uh, yeah, this is like this. The power of judging should not be given to a permanent. In other words, he says the power of judging should not be given to a permanent senate, but should be exercised by persons drawn from the body of the people, right? This is the note that those judges, as the office is called in English, are judges as they are make the judgment. The jurors, as the office is, in other words, the jurors, as their office is called in English, are judges that make the judgments. Okay, so therefore, this is why it's an interesting note here. He goes that at the same time of the year, in other words, drawn from people at the same certain time of the year in a manner prescribed by law to form a tribunal which lasts only as long as necessary requires. In this fashion, the power of judging is so terrible among men, being attached neither to a certain state nor to a certain profession, becomes, to so to speak, invisible and null. Judges are not continually in view. No one fears the magistrate. One fears the magistrate, not the magistrates. Right, this judges or the jurors in that sense. In important accusations, the criminal in cooperation with the law must choose the judges, or at least be able to challenge as many of them that who remain to be considered to be of his choice. The other two powers must may be instead to magistrates or to permanent government. In other words, the other two may be given instead to magistrates or to permanent bodies because they are exercised upon no individual, and being only the general will of the state and the others execution of that general will. But the tribunal should not be fixed. Judgments should not be fixed to a degree that they are never anything but a precise text of the law. If judgments were the individual opinion of a judge, one would live in this society without knowing precisely what engagements one has contracted. Further, judges must be of the same condition as the accused or his peers, so that he does not suppose that he has fallen into hands of people inclined to do him violence. If the legislative power leaves to the executive power the right to imprison citizens who can post bail for their conduct, there is no longer any liberty unless the citizens are arrested in order to respond without delay to an accusation of a crime has rendered capital. This case, they are really free because they are subject only to the power of the law. But if the legislative power believed itself endangered by some secret conspiracy against the state, or by some correspondence with the enemy of the outside, it could, for a brief and limited time, permit executive power to arrest suspected citizens who would lose their liberty for a time only, so it would be preserved forever. Right? Again, this is his example of this idea of and I think this is where the English system comes in. In other once you only understand his praise of England by his general account of the division of powers. So it's not that the division of powers is the secret of the English Constitution. It's that he's saying that, in many ways he would criticize England and how England has devolved of its of this, the kind of overly fusion of the executive and legislature. But his argument is the jurors. What made England free was the independence of the jurors and how they did it, because this was the power of judging individual. And this is where political liberty manifests itself most. And the idea of the citizens are free from being government and also free from the imposition of power upon others. So I'll end here. This is my general thing about what I'm going to do in the Montesquieu if we when we do it later. I just wanted to say, show you what it is, and we'll stop here. If you like this, like it, say some things about what you think about this and want more. This is not going to be a general thing. This is my kind of proposal to do Montesquieu. Okay, well, I'm going to stop here. Like it, dislike it. Put your comments below, and we'll see what happens. Okay, take care. Bye bye.